you except for... Hey!
Welcome! Mr. Duggar.
Up there, didn't you?
Yeah, good to see you.
See you.
So cute. Thank you for Hey, Grandma.
Hey, look, they've got their own little family board going over there.
Oh, sweet. Oh.
What did you enjoy? Tell Scott.
Looks like you married a good cook here.
I think the meal was a very big hit.
It's Katie from Without a Crystal Ball. Welcome back to my channel. I hope you're having a good day. It's March 18th and I'm ready for a TGIF and an update on Josh Duggar. I've been going into the case file every single day trying to verify if something new has been filed. And honestly, I have been waiting for an order from the judge regarding Josh's motions. He had filed that he wanted an acquittal or a retrial or whatever, and we're still waiting for an answer from the judge. And then they also had their sentencing reports that they filed their responses to last week. And so I was like, well, maybe there'll be something more around that. But thus far, up until today, there hadn't been anything new in his file. And today, when I looked into his file, I noticed that there was a new request from Josh for yet again another delay. And this is, I think, one of the more curious delays that I've seen by Josh's attorneys, specifically because in this case, the judge has been very clear that they don't want a lot of delays. They asked initially for like an 8-month delay. They didn't want to have his trial until February of 2022. The judge sort of conceded a little bit and they did it in November instead of July. But now we have sentencing in 2.5 weeks and suddenly his defense team believes they don't have enough time after having 4 months. 4 freaking months to get ready for sentencing. Makes little to no sense to me, and it doesn't sound like the prosecutors or the U.S. attorneys in this case were very, I don't know, they want to defer to the court, meaning they didn't agree, so they're going to let the judge decide on this. But it's, again, another delay by Josh, and it's an interesting choice for why they're seeking this delay, because part of it comes down to video conferencing and his availability to video conference with his attorney, the same guy that has been video conferencing with his wife like 3 to 4 times a day. Yeah, they say they're having a hard time doing that because of restrictions in the jail. So their argument here is that they're seeking a 30-day extension, and they said that they're doing this because they want to provide additional time to pursue additional information and documentation related to a possible 18 USC 3553A consideration. They also want additional time because there's precautions instituted where he's at which he's being detained, and it's made it difficult for scheduling meetings with him during more ordinary times. They also say that they can be and are willing to be available for the current date, but scheduling issues arising out of unrelated cases would be more easily resolved if the court would grant the requested continuance. Now, in their complete explanation to the court, they don't actually reference that they have a specific trial, so it's so weird to me that they brought this up. But it says that the current date for his hearing is scheduled for April 5th. So a sentencing memorandum has to be filed 14 days in advance, and then they also have to do any downward departures must be filed 4 days prior to the hearing. Furthermore, they say at least 3 days prior to sentencing, they have to notify the court of any substantive pre-sentence investigation report objectives that remain outstanding, which would require the court's resolution. They said that pending before the court are a decision for the judge to make on the motion for a judgment of acquittal or an alternative motion for a new trial, and their objections to the PSR report that was put out by the probation officer. So their explanation here is so funny to me because it doesn't say anything more than the first paragraph. I almost feel like they're just grasping at straws right now because it's so ridiculous. He says, Duggar seeks this brief continuance of the sentencing hearing and related deadlines tethered to the date of sentencing to allow him sufficient time to obtain certain additional information and documentation relevant to advancing a particular section of 3553 factor for the court's consideration in fashioning the appropriate sentence in the case. Furthermore, because of the precautions that are put into place, Duggar, where he's detained, the defense at times has faced delay in scheduling certain attorney-client privileged meetings by video conferencing with Duggar. As such, the defense would benefit from additional time to meet and confer with him in advance of sentencing. Finally, while defense counsel can and would be available for the hearing as currently scheduled, certain scheduling issues arising out of unrelated cases would be more easily resolved. They literally repeat the very first paragraph on the second page. It's so, there's no additional context about what that specific area that they're going to look at under the 3553, which I'll get to in a second and explain to you what that is. It says this request for a brief continuance of the sentencing hearing is not intended to unnecessarily delay or hinder the proceedings, but is instead made solely as to allow Duggar sufficient time to acquire all relevant information which will be necessary for fully briefing his Section 3553A arguments, to confer with his counsel and to alleviate certain scheduling issues arising. They don't at any point share what those scheduling conflicts are. So he doesn't say if he has trial, he doesn't say if he has depositions, he doesn't say at all why he needs this from his professional standpoint. And I don't know why they would need more time under that 3553A, because they've had 4 months to begin with. So they conferred with the U.S. attorneys and they said that they would defer to the court instead of actually making a decision and agreeing to the continuance. So it sounds like to me, whenever the U.S. attorney confers to the court or defers to the court to make the decision, it's an indicator to me and a marker to me that they don't necessarily agree. If they agreed, they would say, yeah, that's fine, do the 30 days. They might believe that this is a delay tactic by Josh's team. So under 3553, which is under a U.S. sentence, it's for sentencing. And it's, so under 3553, it is how the court will determine what the sentence should be, not greater than, not less than, based on criteria in this thing. So it's what they use to determine sentencing. And it says the first thing that they could consider is the nature and circumstances of the offense and the history of characteristics of the defendant, the need for what the sentence imposed would be. So to make sure that the sentence reflects the seriousness of it, to avoid adequate deterrence, to protect the public from further stuff by him, and to provide the defendant with needed educational vocational training. What kind of sentences are available? So is it in-home detention? Is it probation? Is it in-home detention? Is it going to a facility? What kinds of options are available? And then the kinds of sentences ranging from, there's one specific thing in here. It says the need to avoid unwarranted sentence disparities among defendants with similar records who have been found guilty of similar conduct, and the need to provide restitution to any victims. So basically they want to evaluate Josh, the sentence guidelines, and the time that Josh would be sentenced, and what kind of sentencing or facility or option they believe is the best for Josh. And if I was gambling on this and said, what is it that they're specifically looking at? I wonder if they might be looking at the unwarranted sentence disparities among defendants with similar records. Josh is a pseudo-celebrity that has a lot of infamy from his time on Counting On and just his history and then his family's fame. So there would be there could be a factor in the sentence here where they may come up with a tougher sentence on him because of his position in society, to make an example of him. My question here would be, are they looking at the sentence that has been recommended, or the score that's been recommended by the probation office? Are they going to try to argue that it's only been given to him because of his status and it's unwarranted? Or are they going to be looking at extenuating circumstances and factors that might have contributed to Josh doing what he did? Are there other issues at hand that could play a role in this? I don't know. But they somehow, after 4 months, don't have enough information on Josh to go to sentencing in 2 weeks. I don't know. I don't know if I buy this. I don't know what the judge is going to do on here. On the one side, I don't think a delay is horrible because it's like, well, 30 more days, what more? If Josh is trying to delay the inevitable, I mean, it's just he's 30 more days of time served in Arkansas instead of in the federal system. If they think that there is something warranted under that section that will, prove something to help his sentencing, I don't know what that would be. And then I don't know, because they were so vague about COVID restrictions at the jail, they didn't really say why it was hindering them, because it's weird because Anna can talk to him at any time. His parents are doing video chats. I'm assuming that these can be done privately when he's doing them. They kept saying attorney-client privilege. So I don't know if they're having trouble scheduling these in a room where he can be by himself, if that's part of the problem. Taking out my own assumptions about me just assuming Josh is trying to delay the inevitable and assuming that he really has real reasons for this delay, I still don't know what the judge is going to do. This case in particular, he has been impatient with Josh, and he's been impatient with Josh's attorneys, and he has said more than once that he doesn't want delays that are not necessary, that are just trying to delay the inevitable, because that's what Josh tried to do with his first delay. He wanted 8 months from the trial date instead of like the normal 4. And he said like no more delays. And so the repeated requests, like every turn that we have with Josh, there's a delay, there's a request for a continuance. And requests for continuances are not abnormal. So I don't want to say that like Josh specifically is being difficult here. I just don't know if the arguments that they have are very valid or not, because they were so vague in why they needed the continuance. There was literally no substance because they repeated the same paragraph twice. And I thought it was weird that they didn't mention what the scheduling conflict would be. And I also just thought it was odd that they mentioned that there was 2 pending things before the court. One question I have in this is that did they file this motion as a way to like light a fire under the judge because the judge hasn't put an order in on the motions to acquit or or a new trial? Are they trying to like remind the judge like pending before the court we have this stuff, and next week we have to file this stuff about the for sentencing we have to file briefs next week? Long story short, I don't know what the judge is going to do. I can only say that this to me could go either way. The prosecutors or the U.S. attorneys clearly don't agree with them. That's why they're going to defer to the court. I could see the judge granting it just because, and I could see him denying it because Josh is annoying. I mean, Josh has been so difficult to the court throughout this whole process, and indignant and just so arrogant and just defiant of pretty much everything. So I don't know. Long story short, it's just another delay tactic, and if it works, it works. If it doesn't, it doesn't. And it's just inevitably going to delay the inevitable for him. Whether it's 30 days from now or 2 weeks from now, he's still going to be sentenced. And I don't really understand how 30 more days at this point is going to help him in any way, shape, or form. To me, it just seems like another stall tactic by Josh, and I hope the judge sees through this. But who knows? I mean, it wouldn't be the first time another continuance was added. And again, it's just more delays of what we all want, which is Josh to be put away for as long as they can put him away for. Wonder, though, if there's a big sentence looming, and that's part of this, because he's really acting nervous. And I don't know. I'm still like, what's the sentence that they're going to give him? Is it going to be 10 years? Is it going to be 20? Is it going to be 50? He can't have 50, but you know what I mean. What are your thoughts about this continuance? Do you think Josh has valid reasons? Does he not have valid reasons? And how do you think the judge is going to respond? Will it disappoint you if the judge agrees and gives him the continuance? Or are you just like, whatever, it's 30 more days? Tell me your thoughts in the comments below. Bye, guys.